Hi everyone, welcome to another episode of the Law Society of Singapore's Building and Construction Law Committee podcast series, where we speak with thought leaders and experts in the field who will share their insights on key issues shaping construction law and practice. I'm Marcus Chia, a construction lawyer based in Singapore and a member of the committee. Today I'm joined by Senior Counsel Nuala Simpson, one of Australia's leading barristers in engineering and construction dispute. She has appeared in the Federal Court, the Supreme Court of New South Wales, and in major international arbitrations across the Asia Pacific. She's consistently recognized in Doyle's Guide and Best Lawyers Australia and was recently ranked as a global thought leader in construction law by Who's Who Legal. In this episode, we will be focusing on two core aspects of advocacy in construction disputes: how to persuade at the opening statement and how to cross-examine witnesses and experts effectively. Without further ado, let's dive right in. So, Nuala, what are the key elements of an effective opening statement in a construction dispute?
Well, I take that to mean an oral opening. So I'll address my question by reference to oral openings, or I will touch on written openings. And of course, there are different elements that are relevant to an effective oral opening for a claimant versus a respondent. So I'll deal with a claimant first. As a claimant, the key function of your opening is to introduce the tribunal or court to your case theory. And by case theory, what I mean is that even in the simplest of cases concerning time and money, there can be some overarching themes that, as the plaintiff, you may wish to foreshadow to the tribunal or the court. And as an advocate, one seeks to identify these overarching themes because, except in the most technical of cases concerning just pure contractual construction or statutory interpretation, concepts of fairness and merit can play a role in the decision making. Having said that, a claimant's opening should also provide the tribunal with an introduction to the matters that are the subject of the dispute and a roadmap as to how you intend to run your case. And by introduction, I mean identifying for the tribunal the key issues in dispute, identifying the key aspects of the contracts or the statutory instruments that you intend to take the tribunal to in closing, so that they are cognizant of the key aspects of those different instruments. And then the key concepts around the technical issues that they will need to understand in order to understand the evidence. For example, if your dispute were a dispute about the niceties of welding, it might be necessary to explain the nuances of different types of welding methods and different welding techniques. You also need to provide a roadmap to the tribunal as to how you intend to run your case. And by that, I mean what evidence you intend to lead in order to prove your case. In terms of lay evidence, speaking for myself, when I'm opening a case, I tend to focus on the documentary evidence. Witness evidence is always, as we know, liable to be, usually, particularly in courts, and often in arbitration, is liable to be traversed by cross-examination. And if you open on a fact that has been derived from lay evidence and that fact is disturbed in cross-examination, then that can undermine your case. So it's better to focus on the documents if you can. Of course, sometimes you can't do that because there are disputed conversations that are central to the dispute, and you may need to touch upon those in opening. In terms of expert evidence, sometimes it's just enough to identify for the court or tribunal the points of difference between the experts that the tribunal will need to adjudicate. And if you keep it at that high level, then you leave yourself the flexibility in closing to advocate for your case based on the opinions as they emerge following cross-examination. A good oral opening is usually assisted by a core hard copy bundle of documents that you would provide to the tribunal and your opponents, that those being the documents that you think the tribunal will need to digest in order to understand the case. That's a helpful thing to do because if you provide that bundle up front, you may find the tribunal adopts that as the basis of their own key set of documents, the backbone of their own documentary bundle that they use to dispose of the case. And a good oral opening is obviously always assisted by some good oral written submissions, which include useful chronologies and dramatis personae. In terms of the last thing I'll say about a good oral opening for the claimant is that, or two things. While it's important to be persuasive in your oral opening, and I think I've sort of already alluded to this in the way that I put the evidence in opening. In my view, it's important not to put your case too highly. It's important to remember that your opponent will come back to your opening when they come to close the case in an attempt to demonstrate that you haven't made out the case as you put it in opening. So if your case is put in a balanced way in opening, that will give you more room in closing to finesse your case. That can be required where, for example, the evidence in hearing doesn't fall out precisely in the way you expected it, meaning you might need to pivot a little to take into account new facts or opinions. And I'm suggesting that opening in a balanced way will give you more flexibility to manoeuvre in that way if you need to. The last thing I'll say about opening for a claimant is a tribunal is always very mindful of housekeeping matters. So a good advocate will, at the end of the opening, address the tribunal on those sorts of matters that will be top of mind for the tribunal. So how will the court book be managed? How will exhibits be managed? How will the tender of documents be managed? That's important to the tribunal because the tribunal will be very conscious to understand the universe of documents it must be across in order to resolve the dispute. In terms of for respondents, it really depends upon the way in which you have attacked the claimant's case. If, for example, your attack of the respondent of the claimant's case is to merely put the claimant to proof, then there may be very little for you to open on, because if you're planning to simply pull apart their case by cross-examination or objections to their evidence, then it's not really going to serve you very well to highlight your mode of attack at the beginning of the case, because the claimant will just pivot to try and address that before you deploy your defence. So you may be best placed to keeping your powder very dry. On the other hand, if you have positive defences or expert evidence of your own that you need to rely upon, or you have cross-claims or counter-claims, then you may wish to open on those. And when it comes to opening on those matters, the considerations I've just outlined in relation to the claimant's opening would apply in fairly equal measure.
Thank you, Nuala, for sharing these insights. As you've alluded to earlier, construction disputes often involve dense facts and technical issues. So what strategies do you use to present those issues clearly when deliberating and opening?
For my part, a picture paints 1,000 words. And in complex cases, it can be very difficult for even the best advocate to explain orally the true nature and size and scope of the project that is the subject of the dispute, or the complexity or interrelationship of technical matters. And so a good advocate will always seek to combine their oral advocacy with pictorial, graphic, photographic props, if you like, presentations or PowerPoint presentations to help the tribunal visualise what it is that you're advocating for or seeking to describe. And a very good advocate will ensure that these props are deployed again and again during the hearing, during cross-examination of lay and expert witnesses, and later in closing, to help the tribunal reorient itself again and again on the complex matter that it is that you're seeking to address in cross-examination or by way of closing submissions. In cases involving delay and disruption, it can be very helpful for the tribunal to see a presentation of the project, if it exists, for example, in a time-lapse video, to show how the project started in the ground and then emerged from the ground and then rose upwards or downwards. It's a station in the ground, for example. That can be extremely useful for the tribunal to conceptualise how this thing came to be. If one doesn't have access to time-lapse video, then another method that can be used, and one that I've used myself, is one can engage computer programmers or animators to prepare a model, a 3D model of the construction of the project based on the as-built records of the project itself. And that, again, can be very helpful. You can take the model to certain points in time so that the tribunal can envisage at one particular point in time or another precisely how much of the project had been progressed at that point.
So beyond clarity, conversation, as we all know, often turns on narrative. How do you put forward a compelling narrative in the opening statement without overwhelming the tribunal or the judge with technical detail?
Well, you use the word narrative, whereas I would use the word case theory or themes, but I think Marcus, we're talking about the same thing here. It's a real art to identify the key points that you wish to make without overwhelming the tribunal with information. There's obviously only so much information that the tribunal can absorb. But the best case theories are usually the most simple and the most obvious ones, the most believable and credible ones. So that's to say that your narrative, if you want to really speak to the tribunal, must really accord with the actual facts, not the facts as you might wish them to be, and certainly the facts as you expect they may fall out. And your case theory, your narrative needs to speak to plain old human common sense. It needs to be believable, and you need, in my view, a good advocate will not stray into conspiracy theories and the like. That's the same as me saying earlier that you are careful in opening to not put your case too highly. You effectively keep your powder dry and save it for closing. It's an art to identify precisely all the facts that you deploy. If you're struggling to articulate your case theory, it's taking you many paragraphs to articulate it. It may be that you haven't found the simplest and most obvious answer that spans across your case.
Thank you, Nuala. So now let's move on to cross-examination. What are the most common challenges you face when cross-examining witnesses in construction dispute, whether factual or expert witnesses?
The key challenge in cross-examining lay witnesses is that they're not bound by the code of conduct that experts are often bound by, and they're not cross-examined as expert witnesses often are in a hot tub together with respected experts in their field. So that means that the only check and balance as to lying on the part of a lay witness is really you and your skill, and sometimes the skill and expertise of the tribunal or court who may identify inconsistencies during the course of cross-examination. The key challenge in cross-examining experts is fairly obviously that they are experts in their particular field, whereas you are not, at least not as expert as they are. This means that there's a risk that if you stray into areas of highly technical expert evidence, you will elicit an answer that is damaging to your case because you don't know enough to realise that your question is badly formed, or you don't properly understand the full range of answers that could be given in response to your question. They're the key challenges I face when preparing for cross-examination or delivering a cross-examination.
Turning specifically to factual witnesses, so what tactics do you use to uncover their inconsistencies in their testimony?
Well, in my view, a good cross-examiner of lay witnesses possesses the following 4 factors. The first is they have a very highly, I'd say, detailed knowledge of the facts, including the contents of the documents, the subject of the dispute, the timing of the dispatch of those documents, emails and the like, including down to the hour, sometimes minutes can be important, the dates and times when meetings occurred, who was there and what was said, because it's largely through your very thorough knowledge of the facts as they appear on paper that you will detect in a question and answer that does not align with those facts and is inconsistent with them and is likely to be a lie or an inconsistent statement. The next feature a good lay witness cross-examiner possesses is an ability to listen carefully to what the witness is saying and pivot. Sometimes as a cross-examiner, you'll ask a question of a witness and you'll receive an answer you don't expect. The inexperienced cross-examiner will think, oh, I've received an answer I don't want, I'll skip over that question, I'll move to the next question. But the great cross-examiner will pause and consider the answer and very quickly and carefully consider whether that answer actually poses an alternative or new chain of inquiry for cross-examination. That's something you need to do in order to carefully and successfully cross-examine a lay witness. There's 2 more features. The first is, I think the good lay cross-examiner has the ability to detect through the demeanour of the witness, their tone and their body language, whether the witness is under pressure, that is to say, lying. The other factor I think the good lay witness cross-examiner has is ability to ascertain how best to elicit concessions from a witness. Different strategies or approaches to cross-examination can suit different witnesses. And what I mean by that is, for example, you might have a witness that you realise that so long as you put the question in a way that isn't directing criticism to them personally, that they may be very happy to accept a proposition. So you may realise that if you take some of the inflammatory language out, if you put questions more neutrally, if you give them an excuse for why they didn't know something or how it could have been that they failed to do something, i.e. because someone didn't assist them or let them down, then you may find that the concessions that you want come out more readily. They're the 4 tactics for dealing with lay witnesses.
So turning to expert, as you mentioned earlier, experts are experts in their own field and you have to tread with caution there. So from your personal experience, how have you prepared your case such that you remain in control of both the technical details and the overall case strategy?
The way, in my view, there's 3 main ways of attacking an expert witness, not necessarily in this order, but the first way that you deal with a expert is to attack their independence if it's appropriate to do so. So if, for example, the expert has a financial interest in the outcome of the proceedings, then it would be appropriate to cross-examine the witness on that topic. However, I find that most experienced tribunals form their view about the independence of an expert based on the way in which the expert responds to the substantive questions that are asked of the expert. So if the expert is not making appropriate concessions, for example, or is advocating for a position or making speeches when they're not asked to, then that expert, in my experience, tends to be less trusted than those that do make appropriate concessions and don't advocate for their client's position. The next line of attack is to attempt to attack the expertise if you can. In the context of construction, you see this happen a little more in the context of programming and quantum evidence, because many construction counsel have had a lot of experience in cross-examining in those fields of expertise, and they do then tend to be more comfortable in straying into the disciplines themselves. It's obviously extremely hard to cross-examine on technical areas of engineering and the like. And if I were planning to cross-examine an expert on the matter of technical engineering, then I do two things. I obtain the assistance of an expert in the preparation of the cross-examination. That's to say, I would retain what we call in Australia a dirty expert, which means an expert that's not actually engaged to give evidence for you, an expert that assists you in preparing the case. And I have cross-examined technical experts with a dirty expert next to me at the bar table to assist me if the expert that I'm cross-examining gives an answer that I don't expect, and I need some assistance in pivoting the response that's been given to me. So that's the second method. And the third method that is the most uniformly deployed and the easiest is to attack the expert on the assumptions that they've made, that is the facts. Most experts caveat their evidence by saying that it depends upon the correctness of the facts that they've been briefed with. So most experts will usually happily make concessions when it's demonstrating cross-examination that the facts they are relying upon are not sound. So they're the three ways in which I prepare for expert cross-examination. I look at their independence, I look at whether I can effectively attack their expertise, and I look at the facts that they're relying upon to see whether I can attack those to undermine their opinion.
So lastly, as you've alluded to earlier, experts love the jargon. So how do you cut through that during cross-examination so that the tribunal or the judge actually understands the point that you are making?
Well, I actually deal with that at the beginning and opening. So if there is technical jargon, so if, for example, you're dealing with a case of welding and there are nuances as to the type of welding being used or the machinery, the automated machinery that's used for welding, then I would take the time to take the tribunal through that, because it's going to be impossible for the tribunal to understand the lay evidence, which comes before the expert evidence, let alone the expert evidence. So that's the starting point. And then what I will do at the beginning of a cross-examination, whether it's a traditional cross-examination or a cross-examination hot tub, is I will ask the expert or experts in a hot tub to accept propositions as to what certain words mean. So that at the very beginning of the cross-examination, the tribunal is reminded of these propositions so that when they are used, they will understand them.
So that's all I have for you. Thank you so much for sharing your insights today, your thoughts on the art of presenting a good opening statement, taking the tribunal through an effective narrative, and on cross-examination really highlights the craft involved in advocacy in construction dispute. Yes, I hope you found this discussion useful. I'm Marcus Chia, and this has been another episode of the Law Society of Singapore's Building and Construction Law Committee podcast series. Thank you for tuning in, and we'll see you next time.